Hello, 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 check. Hello, hello, check. Hello.
I request everyone to kindly keep your cell phones in silent mode. As the honorable dignitaries are arriving, I request our honorable Additional Director, Karnataka Judicial Academy, Shri K. Narayan Prasad, sir, to kindly escort the dignitaries on the dais. Honorable Ms. Justice Anu Shivaraman, Judge, High Court of Karnataka and President, Karnataka Judicial Academy. Ms. N.S.Nappinai, Senior Advocate, Supreme Court of India, Founder, Cyber Sati. I also welcome all the honorable judges of High Court of Karnataka, registrars, judicial officers, and the law clerks and interns. Good afternoon. Please. With your permission, Your Ladyship. Ano Badraha Kratahu Yantuhu Vishwataha. Let noble thoughts come to us from all directions. Good afternoon, everyone. A warm welcome to all of you present here today for the second lecture in the Karnataka Judicial Academy's Silver Jubilee Lecture Series. The Karnataka Judicial Academy's Silver Jubilee Lecture Series is a significant initiative to celebrate its 25 years of excellence in legal education and training. We are privileged to have such a distinguished gathering today as we explore the vital topic of cyber justice, the role of judges in the digital age. As the world evolves at an unprecedented pace, it is essential to understand how the judiciary is addressing the challenges of cyber law, digital crimes, and online justice. We are truly fortunate to have with us today Ms. N.S.Nappinai, Senior Advocate, Supreme Court of India, Founder, Cyber Sati, with us, an expert in cyber law who will provide valuable insights into this important area. Now, to begin it formally, it is my great honor to invite Honorable Mrs. Justice Anu Shivaraman, Judge High Court of Karnataka and President Karnataka Judicial Academy, to kindly deliver the welcome address, introduce today's esteemed speaker, and set the tone for the event.
Larigu Namaskara. Very good afternoon to all of you. It is my great privilege to stand before you today to welcome each and every one of you to this afternoon's lecture, as also to introduce the guest of honor for the day. It is our privilege to have with us today Advocate N.S.Nappinai, who is an authority on cyber laws in India. We have great pleasure, ma'am, in welcoming you today, and we are sure that this gathering, which consists of judicial officers, high court judges, judicial officers, law clerks, interns, law students, trainee judicial officers, will be definitely enriched by the lecture that is going to be delivered here today. We are aware that we have with us somebody who is totally equipped to give us this lecture on cyber laws today. Advocate Nappinai has over 33 years of experience and is a trailblazer in the field of cyber laws in India. She has conducted cases relating to cyber laws, constitutional laws, intellectual property rights, corporate law, and brings her great expertise to the lecture here today. She has worked not only on legal reform in cyber issues, but also played crucial role in educating and training judicial officers, law enforcement agencies, armed forces, industrial professionals on electronic evidence and cyber laws. Through her initiative Cyber Sathi, she has empowered countless individuals, particularly focusing on child safety online and helping equip children, teachers, parents with the necessary knowledge to combat cybercrime. She has asked me not to elaborate too much on and has warned me to keep my introduction short. But I would be failing if I did not say that she has, as a matter of fact, being involved in the Parliamentary Committee on Women's Empowerment and in the National Cyber Security and in the committee which has been involved in empowering the National Cyber Security Policy for the year for 2020 to 25. And that we are looking forward to hearing from you, ma'am, and we hope that this becomes an interactive session and that all of you are able to make the best of this afternoon's lecture. Thank you. Thank you very much.
Thank you, Your Ladyship. I would also like to take this opportunity to extend a warm welcome to Honorable Mrs. Justice Anu Shivaraman, Judge High Court of Karnataka and President Karnataka Judicial Academy. Her leadership and unwavering guidance serve as a beacon of inspiration for all of our initiatives. I welcome Your Ladyship. The most anticipated part of today's event, the address on the cyber justice, the role of judges in digital age. It is my privilege to invite Ms. N.S.Nappinai to share her insights on the important topic. Ma'am, the floor is yours. Yes.
Good afternoon, everybody. While we await some of the paraphernalia that is to come here, just to set the pace for today. Respected and honorable judges, respected dignitaries in the room, thank you all for being here on a Saturday afternoon. I always quote Walt Disney when I start by saying, my job is to entertain and I hope you will be educated. So today's session is not just meant to be a lecture, it's meant to be just sharing of information and knowledge, and in a manner which I hope will entertain and educate. Can I have? No, I'll just take this because I should have known that earlier. Thank you all. So, as the first step, what I always do is I'm one with y'all, and therefore I don't stand behind a podium. I'm here out here so that, as ma'am already mentioned, let's make it an interactive session. Whenever you think you have a question to ask, just put your hand up. As and when I finish a particular topic, then I will come to you. And my one request would be, since we have a lot of ground to cover, keep it short, your question, and make it a question. Let's not have a debate here. I'm totally available for you post the session for any debates or conversations that you may want to have after the session, right? But when you interact is when a session really gets the best value out of time. So please make it interactive, and I look forward to that. The next part of the announcements part of it is we have an amazing topic that has been given to me by Justice Anu ma'am, and it's something that is top of our mind today. We recently had a session which was a joint initiative between the Supreme Court of India and the Singapore Supreme Court, where also we have talked about the use of AI in courts. So issues about cyber justice are top of our mind, and as young practitioners, young to-be practitioners, young judges, and very senior judges who are now adapting to technology. To quote Prensky, you have still in the room some of us who are digital immigrants and many who are now digital natives. So for all of us to adapt to technology, to use it effectively in justice dispensation, whichever side of the bench we are in, and to see how best such usage is not impacting the rights of persons. It could be the rights of litigants, it can even be the rights of judges or the lawyers, right? Everything should be balanced in such a way that we adapt to technology in a reasonable, responsible manner. So the first part of my session today will focus on cyber justice in the context of how technology can be utilized in courts and where do you see the footprints already and where are we heading in the future. The second part has been added so that all of you who may want some practical inputs also can utilize that portion for your queries, and therefore that focuses, and I am primarily trying to pass certain messages on through case laws. So the second part is actually particularly for the role of the second aspect of the topic there, which you see, the role of judges when you're talking about cyber. So the second part of the presentation will focus on what is the expectation from you as a judge when you are dealing with cyber. It could be cyber-related matters. The first part will also cover how do you adapt cyber into your work culture, and the second part on how do you deal with it when you have a case in front of you. So often I'm asked this question, do you only specialize in cyber laws? And I tell them there is actually no such separate vertical in that sense, because when we started practice, firstly, we didn't have cyber, but then you had these clearly delineated verticals like criminal, civil, corporate, etc. But look at what happened today with cyber. Cyber is a horizontal. There is no field of law where there is no impact of cyber. There is nothing today in terms of your everyday work where you will not come across some issue or concern pertaining to cyber or the digital space. So today, when we speak about cyber laws, we are talking about a horizontal. I've called that the cyber law jigsaw, in fact, in my first book, because the issue then is about where do you find the law that fits the situation. So you have to then go treasure hunting for it. That's a concern, but that's the way it will always be. You cannot have a one-size-fits-all law for it. So with that, let's move forward. And as I said already, please feel free to put your hand up so that I will pause where I can and then I'll take your question. This is just a small quote from me, and I found it very interesting when one of my juniors asked me the context of the second part of the quote. The first part we all know about, what is it that guides us? Memory genes. You must have heard of it, right? One of the most interesting things that I have done when I was still in Chennai was something called a turtle walk. So turtles a turtle comes and lays its eggs in the beach, and it gets hatched, and then the turtlelings then move automatically towards the water. But we found out that suddenly all of them were running towards the road and then getting killed under the car tires. So we had to create methodologies to protect them, and we were wondering why. The reason is that the turtle's memory genes are wired to run towards the lighter horizon. So normally when you look at the sea and the sky, you will realize that that place where it meets becomes the lighter horizon. So they were running towards it. Now when you have lights on the road, they get confused and they run in the opposite direction. So that's the reason for the second part of that quote you read there. But what I'm trying to say here also is the same thing which I mentioned earlier about digital natives and digital immigrants. We as digital immigrants did not have memory genes to guide us in terms of cyber. We did not know how we were going to deal with issues or concerns that came up when cyber was evolving. Today's digital natives already have some level of guidance, but it is about focusing it in the right way, for the right purpose. Let's see how best we can do that. Where should I point for it to move? There it does. So I already talked about this slide in terms of what is the roadmap for today. So I'll move forward on that. Well, this is a bit of a tall order, what I've mentioned here. But we will try. We will try to cover all of these aspects too. I'm not able to get the pointer here, but never mind that. Yeah, this one. These may be a bit difficult to cover everything, but often I've noticed that particularly with the complexities that electronic evidence poses before us, we tend to ignore the other aspect, the technical aspect, which is with respect to jurisdiction. There have been some very interesting cases that have evolved this construct too, so I would be happy to address it, if not during the session, then thereafter, right? So let's move forward in terms of what we understand as cyber justice, right? First principles. So whenever I give a session in cyber, the first thing I tell people is, please forget the word cyber. It may seem like a bit of a contradiction in terms, but believe me, it works. The minute you think of it as cyber law, you think it's something very complicated and you'd rather avoid, or you get scared about that field. When you think about law, that's your domain. You know it all. So it's only one aspect of law that you're dealing with. So the domain should not worry you or scare you away. Similarly, when you talk about electronic evidence, the minute you ignore the word electronic, you already know what to do with evidence evaluation and evidence gathering or evidence considerations, right? So that's what first principles are all about. Once you know your first principles, then you know what you should do the right way. Similarly, when we talk about cyber justice and adapting technology into court systems, one of the first things that I'm always asked is it permissible for us to use generative AI? Is it not better today, post-COVID time, in terms of access to justice? Because you now have access not just for lawyers or judges, but also for litigants. You have better transparency in terms of what is happening in a court of law. They are able to see what is happening without having to spend a fortune, for instance, traveling to Delhi to the Supreme Court, etc., right? So when we talk about access to justice, it's not just physicality. It's not just about territorial or physical access to a court. It's about the cost that is involved. It's about the ease of access. It's about transparency. It's about effective access. So these are just some of the constructs that I have captured here, which will tell you about what is it we are talking about when we talk about cyber justice in the context of accessibility. Because one of the first constructs that come up when you talk about cyber justice is access to justice. How can technology help you in ensuring access to justice? Can it give you a better access? Can it improve the processes in such manner that it is effective access? And of course, it is cost effective, and that is needless to elaborate on itself, right? But it is not totally cost effective, as we will see as we go forward. Sometimes we always say, you find, because technology is a new toy in our hands, often we also tend to forget that we are looking for a problem for the solution because we are so excited about the solution. So it's an expensive solution. So you may not have a cost aspect as a litigant, but there is certainly a cost aspect for the system, for courts, for governments. And therefore, a technology solution needs to be evaluated in the context of, is it the right fit? Is the trade-off in terms of the cost to be expended correct or appropriate in the context of what is the solution it is providing or what is the problem it is countering? So these are the aspects we'll be looking at very briefly in the context of different kinds of technologies. I have to remember to point in the other direction. So, can these monitors be activated so that I don't have to turn back every time? Yeah, right? I still don't know whether it's moving or not unless I turn around. So, and I have to know where I should point. It's almost like, I have a gun which can go whichever way. And yeah, so now I need to go back to the previous slide. There. This kind of like slows down my flow, but pardon me for that. But I'm not able to figure out where the thing works. The pointer, there it is. So now it's working on this side. Where do I point to make it work? You are doing the change. That's why the lag time. You now learn one more thing about technology, right? So we always talk about the lag time, and now I realize the lag time is physical, not my problem. So I will then just say next, please. And can you just activate these monitors so that I don't have to look back? I can then look in front and speak. If you can. Okay, so then could I please have the next slide? Until that is resolved, you get me moving back and forth. Thankfully, I never look at my slides. I just have that as placeholders for you all to have something to look at other than me, right? The next slide, please. At least now I'm not going to use this, I'm doing away with it. I have a better remote with my voice command now. Again, a technology in a different way. See, this is something I added because it's a very old cartoon, as you can see from the year itself mentioned there. One of the earliest New York Times cartoons, which you have here, tells you about how you could be a dog on the computer thing on the internet and nobody will know. Is it any different today? You can be you on the internet and it may still not be you. And that's what deepfakes are all about. Right? So when it comes to technology, one of the first issues that you're going to have is how safe is it? How are we going to move towards a different kind of adaptation of technology where technology itself can fail you? Where are the pitfalls? Where are the issues or concerns? And is it something we should address first? And therefore, I'm addressing this aspect first. Because the excitement, as I told you all about a new toy, will always be there. But when you're using a new toy for something as serious as justice dispensation, you need to be really careful where the pitfalls are. The next slide, please. Now, I want you all to tell me, have any of you all read these two quotes? There is one from Justice Krishna Iyer. Isn't that a beautiful quote? Look at how forward-thinking he is. He speaks about, technology when wielded with compassion and wisdom becomes a powerful tool in the pursuit of social justice, bridging the gap between the privileged and the underprivileged. Isn't that a beautiful quote? Have any of you all read the quote? No? None of you. What about the former Chief Justice of India's quote? Anybody has read it? That must be more recent, right? So crisp and to the point about, justice being the beacon. You can imagine that light there, and the technology must be the bridge, ensuring accessibility and inclusivity for all. Why is it none of you all have read these two wonderful quotes? Anyone has any ideas? No one. Come on. All you millennials, I'm constantly looking at you all because I think you're going to provide the solutions. Okay, now be more alert next time. Next slide, please. Sorry, I'm breaking the mystery right away. I love this Mad Hatter's quote, particularly when it talks about what is not often, and what is not is. And that invariably is what technology brings to you. That uncertainty of whether what you're seeing is or is not. Or you think it is and it is not, or you think it is not but is. I think I have confused you all as much as a Mad Hatter can. So what exactly am I talking about? And for those of you who may not know who the Mad Hatter is, watch Alice in Wonderland. So let's move to the next slide, please. As some of you all with your very vigorous nods had figured out, a little late after the Mad Hatter kind of gave you that, hint. Both of those quotes are not authentic quotes. Both quotes were AI generated. But you saw how real it sounded. right? There are many other quotes that AI will give you, but the very fact of the use of AI in the quote is a dead giveaway. Because there is no way Justice Krishna Iyer would have talked about AI in courts. So therefore, I had to be really careful to pick and choose that quote, which was generic, but did not, but still to the point today. Of course, Chief Justice Chandrachud's could have had it, but again, I preferred to take a generic quote there. But this is what technology is all about. So the question I asked you all earlier, why can generative AI not be used by judges to ease their burden? Why can generative AI not be used by lawyers to ease their burden? After all, it gives you answers in a few seconds, which definitely juniors may not be able to. We ourselves may not be able to sometimes, right? We may still want to spend a few hours, a few days before we give an opinion because we want to be careful, right? But when it comes to generative AI, and it gives you answers, and you know today it is giving you answers even for your general searches. So when you put a search on Google, I knew I was giving a post-lunch session. There was a reason why the Mad Hatter was there, by the way, right? So now I have all of your attention. So now let me just tell you all, when you give a general search, the first answers you get are based on generative AI. Okay? In fact, interestingly, one of the answers it gave, and I don't remember why I put that search, or maybe my husband did it just to show me he loves to play around with Gen AI. It tells me that Cybersati is not a private thing. It is a division of the government. That's the non-profit I have founded. So I'm being told that it's a division of the government doing XYZ kind of work. Why I'm mentioning this answer is that you may think, that's why the dog cartoon. You may believe everything you see in the internet, but everything you see may not really be. So as lawyers, when we do our research, I'm sure particularly old-timers like me have heard this, and we have also repeated this. Do not rely on head notes in a judgment. Read the judgment, because only the content of the judgment matters, not the head notes. Head notes is prepared by the publisher of the journal. So it may guide you. It's just like a signpost. It cannot be the final destination. The judgment is the destination, right? We know this. When we look at a generative AI output, why have we forgotten our lessons? Why is it that we forget it could be a dog on the internet giving us those generative AI results, right? The reason is this. When you look at technology and its usage, the biggest enemy is not about the system. It is convenience. So when we want to use technology for convenience, we should, but not at the cost of caution, not at the cost of the work you would put in anyway. So by all means use generative AI, but let that not be the destination. Thank you all so much. No, I don't need that. Now you people are my prompts. So I will request for the next slide from you all, please. So all you have to do is, by all means use generative AI. Nobody needs to stop you. We have adapted technology in various ways to make our lives a lot easier. We used to complain earlier that cut and paste was the biggest problem that happened in law. Now it seems to be AI, right? But AI is not the problem. We always say in technology that the human is the weakest link, because the strongest of technology can be weakened because the human will not follow the processes mandated, or the human brain is so sharp, it will find the circumvention. It will figure out a way to make the strongest technology weak. We know how to use and misuse technology, right? So here again, the problem is not with generative AI. The problem is with the user and to how much extent you are going to rely on generative AI. Use it only to fill up a blank page. but don't use it as the final product. The Mata case, I don't know if I mentioned it in this, or the next slide, please. The Mata case, which is the US lawyer who used non-existent case laws and has been sanctioned for that, really rests on the same principle, that the search results he got were just the first step. All he had to do was verify whether these cases really existed. His defense, interestingly, was he asks the Gen AI, are these cases real? And it says, yes, of course, or so, something to that extent. But that's not verification. That is just a lazy way out, right? Convenience can be used, as I said, for a first level, but not as the final destination. So this is just something I wanted to emphasize with these examples to make you all understand how technology can be used, but where do you draw the line? How far do you go on that? So this is just some of the developments that you're seeing across the world in terms of cyber justice, which is about technology being adapted into court process of filing or a listing of cases, even in terms of finding out a pattern in terms of what kind of cases are being filed, how is it being dealt with, where is there a gap between the effectiveness in terms of disposal, maybe in some instances and not quite so in another, how can we bridge the gap? These are aspects too where AI can come in handy. But if you're going to talk about deciding a case using AI, that's where the line is drawn a little before the outcome, right? So just moving forward, next slide, please. Next slide, please. Yeah, so these were all the early adapters. Just to give you an idea of where are we heading. You're all already familiar with the substantial part of it, but what you really need to focus on are the last two entries there, which tells you what is the additional aspects that are happening across the world and where are we headed. India has been way ahead of the curve too in terms of cyber justice or using technology in terms of law. We could have been even earlier because we had the technology experts in-house in India. But any kind of change comes with resistance. So I remember one of my earliest presentations in terms of use of technology in courts was in 2004, where I was talking about how even corruption and also corruption can be rooted out and transparency can be ensured with the simple process of a tracking mechanism from filing to final order. Because every period of delay will have to then be explained. And how would it be visible? Because there is a tracking mechanism where when a High Court judge opens just the file of, let's say, your, the court you are responsible for, you're the guardian judge for, and you just click on that case, you get the details with dates and the number of days of delay in terms of every stage. Any of you all who have done statutory writ petitions will know what I'm talking about in terms of calculating the delay and becoming answerable for it, right? So in similar fashion, technology, and I'm talking about very early day technology in 2004, but we had that technology. We did not adapt it then. But today we are moving ahead at very fast pace. And as you will see in terms of some of the other examples I would give, it's very interesting to see that we are not just using technology, but we are developing indigenous technology. We are relying on technology that is not just developed in India, but in-house. For instance, by NIC. So that's real development, where you can localize it and reduce some of the risks that also I will be mentioning. Next slide, please. So these are some of the adoptions in India, which you've already seen. there have been a lot of change. I'll just give you some examples so that you understand the impact of it. Otherwise, it's just a slide, you know. So I've been involved not in the e-code project, but in terms of the training modules, you know, creation and all that. But I would hear a lot of talk about what was happening. Just to give you an example, I'm not disclosing anything confidential. It's all in public domain now. So you have certain kinds of cases being dealt with in a judicial magistrate's court A, in jurisdiction A, let's say in some place in Karnataka. Then you have a judicial magistrate functioning, let's say your neighboring state of Tamil Nadu, right, in some part of Tamil Nadu. There are certain kinds of complexities that arise in the trial, in the court in Karnataka. That is a case that has already been dealt with by, let's say, a magistrate in a court in Tamil Nadu. How is the judge, because that's why I'm talking about judicial magistrates. These are not reported judgments. These are days before you had even some of the decisions of the lower courts collated, etc., right? So how do you know what is happening across two states? Within a state between two courts, how do you know what is happening? How do you learn from the brilliant work that one judge may have done in deciding a complex case, the methodology he has followed, the case laws he has relied on to decide that case when you have a similar case before you, right? How do you understand what I told you earlier? The first stage or first phase of the e-code project was dealt with the collation of data, so that data can then be analyzed to see where is something going wrong with the system. And we all know that we are still facing a backlog issue. But technology cannot be a silver bullet. It cannot give you all the solutions that you need to solve a problem, but it can definitely be a first step in terms of identifying the problem and providing some solution to it. Ultimately, it is all going to rely on the human intervention. But to guide you to that solution, you can definitely use technology. And that first step happened with the e-code projects. And today, we are talking about the kind of technologies that it has evolved and has already implemented. And some of those aspects you will see as we move forward. The next slide, please. This is the exciting part of technology in law. So we have talked about all the back-end process work and, yeah, boring maybe, but very relevant and necessary. Imagine all of you all attending this session through your holographic images. Imagine me deciding that, I will take the image of a lion today and then appear before you to give the lecture, right? How cool would that be, right? Am I just talking in the air? What did I have for lunch? But when you look at what's already happened, 2 jurisdictions have already had courts in the metaverse, where animated figures replace you in the courtroom, in the e-courtroom, and they have argued and completed the cases also. It was probably a test run, but it has happened. So interestingly, one of the persons who has commented on one of these articles about the metaverse courts says, can I then appear as a monkey or as a dinosaur, right? So he wants to be a dinosaur in court. We thought courts were dinosaurs, but now they want to be a dinosaur in court, right? So this is where courts could go. There are definitely pitfalls in terms of using a metaverse court instead of a real, physical or even a virtual one. The first thing is, who knows who is behind the screen? Again, now you know why I put the dog cartoon first. On the internet, you could be a dog, right? In court, you could be anybody then. Who is going to vouch that so-and-so? If N.S.Nappinai claims to be the person who is appearing and arguing the case, how am I going to vouch for the fact that it is I? How is a judge going to say it was I who listened to the arguments and I did give the judgment, right? There are certain validations that happen when you do things in a physical form. may not always be so when you do it virtually. Which is why, and this is again, I'm jumping the gun a little bit, but a little aside for you all to understand the background to how cyber laws evolved, across the world. My interest in cyber laws also started around the time when the laws were evolving, and that's how I had the benefit of an early player also. But it was fascinating, and it has been a wonderful journey. So you had your data protection laws coming out first. 1995 was EU's data protection law, 98 was UK's, etc., right? But between 95 to 2000, you also had another very interesting development, which was model laws coming out, ancestral model laws. You first had the e-commerce laws. That was the reason why the IT Act itself was passed, because we had to comply with the undertaking, right, to bring it on par with the ancestral model laws for e-commerce. So the IT Act had no focus on cyber crimes, for instance, in the 2000 version. It was meant to enable e-commerce, period. It was just, in the passing, they also added a few cybercrime provisions there. The second thing that came up was a model law for electronic signatures. So it's really interesting because when you talk about electronic evidence and the relevance of that 65B certificate, which is now 63 BSA, was that even envisaged in a model law? Was it even considered necessary, or did we think we had to plug that weak link of the human in the middle through a certificate? And how does it really help? So how the model law talks about it is, it talks about how when you are creating a technology-enabled signature, it has to imitate a real signature. So how does it have to imitate a real signature? It has to be linked to person first, me. If I'm claiming to have signed, I should be able to say, look, this is why I'm affirming that I signed this document, right? Linked to the person. Then it has to be linked to paper. So once ink touches paper, how much ever you may erase it, there will still be some mark left. So once ink and paper have connected, it's deemed to have been inked for life, right, in a way. So that is how you needed to create an electronic signature. Then it should be so tight that you will be able to find any modification that is made to it. That's why you now have an encrypted signature which gives you a date stamp and a time stamp, and where when you make modifications, it has to be visible, right? Non-repudiation is what they called it, right? And the integrity of the signature, that it cannot be modified, and if it is modified, then you will be able to find it. So this is the mandate that was given, and that is how electronic signatures were created. So when you look at the model law and you look at the IT Act, you will see that a lot of provisions have been included in the Act from there, including in terms of definitions, etc. But when you look at electronic documents and you apply these same parameters, doesn't it answer all the issues that you have? All that we needed was a law which will help us to affirm that the electronic record that is being relied on is linked to person, linked to paper in the context that once it has been created, that's it, right? You will then know when it is created, when it has been modified. You may not know who has modified it, but you will know when it has been modified and what is the alternative. Meaning, what is the integrity of the document post that modification? What is the integrity of the document you're providing, right? So we will briefly touch upon where we stand in terms of 63 and what it really helps on later, but suffice it to say that you have three broad stages in terms of evidentiary value, right? The first is relevance. Is a fact you're trying to prove relevant? That is the first level of threshold you need to cross. The second level is admissibility of a document. Now, when you look at 63, really it is only addressing that second part, admissibility. But just because you have proven that this is a computer output and you have ensured you have given a fantastic 63 certificate and therefore the document is marked in evidence, That does not mean your job is over as a lawyer. You still have to prove the truth of the contents of the document. That is the third stage. So really speaking, when we are talking about 63, it is only addressing that middle part, not the first or the third. So to what extent should we be expending time at that middle stage is the real issue in terms of 63. We'll come back to that. This was just a bit of a detour to give you all some background in terms of how laws evolved also. So we evolved with technologies evolving. We evolved by adapting to those technologies. We understood that these kind of technologies that were coming up needed to be regulated. But most importantly, and the biggest lesson from this which I wanted to share here is, and it's really critical particularly for you youngsters, because in our time many of the people from my generation would vouch for it. Lawyers were looked at as obstacles. Lawyer ke paas jana hi nahi hai. We should never go to a lawyer. Oh, if we go to a lawyer, that's it. You are you're cursed or you're in a bad shape or something. So when did it change? It changed when people understood that a lawyer is there to assist or help you. So we are enablers today. We are no longer looked at as obstacles. We as lawyers also evolved. From people who would only critique, we moved to people who would support, who would help, who would assist and who would guide properly. Right? This became the role change over the period of years. Many decades, but this is the change that has happened. So today you can no longer be that lawyer who will be looked at as an obstacle. That doesn't mean you're going to be a yes-sayer. That just means that you will guide, but guide in the appropriate way with substantiation. You can no longer say, this is the way it is because I said so. You will say, this is the way it is. I'm very sorry to say you cannot do this because this is what the law says. Or because this is what a regulation says. Or because this is a white space where there is no law or regulation, but first principles apply. So if you're violating somebody's privacy and we don't have a data protection law, that still is something you're going to face the consequences for later. Right? We had a data protection law through minimalist provisions. We have a data protection law which still remains minimalist, but is not yet implemented. That still doesn't mean our privacy can be violated. So that's what I mean by being a good guide today, rather than looked at as an obstacle. It's not like we were all obstacles, by the way. We were all guides. It's just that the way we were looked at, the perception varied from what was to what is today. And therefore, the responsibility also changes for you when you're looking at how you're going to use technology in a wise and responsible manner. Let's move forward, please. So now we go to specific technologies, and I look forward to moving to the second part where I will pause and then take some questions in the middle. Some fascinating adaptations. I've always been a big fan of blockchain technology. Not because it was a new toy, but it had so much potential. But this is exactly the technology I was warning you all about earlier in terms of cost effectiveness. So blockchain is not a cost-effective solution. So you should apply it for the right purpose and in the correct manner. Where you believe that the solution provides a better cost-effective alternative to litigants, then that is where we adapt it. One of the earliest adaptations was for putting land registry documents on the blockchain, because you could then track the data backwards and forwards in terms of a land registry document, and with ease, without something getting missed or hidden, or the caveat emptor rule could then be reversed on its head to a little bit, right? So that's something that still continues. If you look at this slide, this is a very interesting take. Now, MeitY has worked on this, and this is from MeitY's paper on this, where they call it judicial chain, in terms of a blockchain for judiciary. What is it that you can use it for? If somebody is relying on, let's say, a bail order, and there are so many cases where bail orders have been fabricated. So when you blockchain it, then before somebody is released on bail, they'll be able to, just with a scan of code, they'll be able to verify whether a bail order has really been passed or not. From a litigant's perspective, it can speed up their release. They don't have to wait for 2 days, certified copies, expedited copies. We are used to all these prayers after a thing. We can do away with all that because within a second of it being uploaded, you can automatically rely on it because it has a blockchain verified process. So these are just some of the instances that they're talking about. If you look at again the trend here, it's invariably a process-driven methodology which is being facilitated through technology. I'm mentioning this with emphasis because this is something I believe in, and I'll emphasize it more in terms of AI later. Next slide, please. I thought I'll use a local example too. So you have your own NIC, Bengaluru also, working on the use of blockchain in the digital space. And if you see it, predominantly it adapts to a large extent the same thing that the Métis paper talks about. But what I've done is I've just added a few more pointers that the NIC document gives you in terms of the benefits and the risks or concerns that you have. You have to keep in mind that one of the biggest negatives when it comes to blockchain is the cost factor. And how much of it is going to become a personalized blockchain. So I would love to elaborate more on permissioned and permissionless blockchains, but I'll reserve it for another day. Suffice it to say, blockchain functions in a particular way of validation, which may otherwise become time-consuming or not very cost-effective unless you evaluate the requirement and work around it. So the next slide, please. Cloud. See, the minute we talk about technology, we have to understand that we are talking about space. We never think about the physicality of space when we talk about cyberspace. So, I was approached for an opinion very, very early. This was, in fact, before the SEBI circular came out in terms of retention of digital copies instead of virtual. The very first circular that came out also was a little ambiguous because they were still testing the waters. So broadly what they did was they allowed you to retain digital copies but did not allow you to destroy the originals. So when an opinion was asked from me or by a trading member, and I said, but yeah, you can digitize it, but you have to retain the physical document also because right now that's what SEBI says. You can't take a chance. And you know what his response was? Ma'am, but do you know how much data we are talking about? He said, this one particular file that we have in digital form, which only occupies this much, it must have been GB, okay, a few, not even terabytes and all, just GB. It will occupy 3 floors of printouts in a football field. That's what we are talking about when we are talking about physicality and cyberspace. We don't realize it, that every footprint you leave actually takes up space. So even in cyberspace, you need space, you need bandwidth, you need technology which can work and work again the same parameters, right? Cost, effectiveness, safety, security. So when you talk technology, those are the other 2 things you need to be much more worried about than a physical aspect. Because when a breach happens, the harm can be exponential compared to a physical breach. A physical breach is still contained within a set of few people or a territory. A cyber breach is not quite so, and that's why cyber security is emphasized here. So when you're talking about court records, court processes on a cloud, here is where the indigenous and the internalization happens, where NIC is trying to develop your own indigenous cloud. So that may be the best way forward. The other alternative, which is what was already mentioned earlier before the current form of the DPDP Act came out, the Digital Personal Data Protection Act, was for data localization. There was a lot of resistance to data localization But there were a lot of naysayers also. And why? In a way, I was one of those, not because I have any problems with data being transferred, but we never think about developing indigenous technologies. Data localization would have helped build businesses in India, not just for data storage, but also data analytics, AI. We are now dependent on big tech to share their data, whereas we would have had the data here to utilize for startups, etc., automatically, right? Data localization was not captured in DPDP. We have to wait and see what is going to come out from the rules, however. But what is not there in the Act cannot really be expanded in that way in rules. The rules are still ring-fenced within the remit of a law. So we'll have to keep in mind that we can't expect miracles from the rules, but we can hope for clarity from them. The next slide, please. Now we come to your favorite topic. Some of the most fascinating things that the Supreme Court has come up with is its transcription, right? We already have a process where English is translated through AI to regional languages, right? But I am proposing that we should now have AI reversing that flow from regional languages to English. Yes, wonderful. I'm told that it's already there because it's too critical. We have seen the kind of money that people expend just to give a paper book copy otherwise for the Supreme Court, right? So it's really critical for us to move forward and backwards in terms of that. You have a wonderful case management system that the Ministry of Law has developed, and you already have on the page all the initiatives of the Supreme Court. These are but just some processes that we are talking about. The next slide, please. So this is where we come to my favorite aspect. And the last quote may be relevant for you all particularly in terms of what should be the best adaptation when we are talking about technology, specifically AI. Next slide, please. This is what I invariably tend to advocate. The first step is, whenever we are talking about the use of technology for anything that is process-driven, like filing, case management, case tracking, maintenance, etc., it is the safest bet. You know, the reason I gave the example of the SEBI issue is, we are still at that stage where we are worried about going totally digital. We have a backup in terms of paper. I'm not too sure that it's a wrong thing. Because, you know, when we used early days of cyber, when we would talk about it, I used to carry an old frayed document also to show people, you know, how life is in our times. You would see that really pristine white paper. You will see it yellowing, graying, you know, and curling at the corner, maybe a little broken. You know, we had to laminate our Bar Council certificates because they weren't just tearing, they were breaking otherwise beyond a point. So you've seen all that, but the document is still in front of you. When you're talking about digital documents, they're today, gone in the next second, not gone tomorrow, right? So you have that sense of fear in terms of longevity of a document. And there are other issues that impact it. It is not just about a system going, into a problem. It is not just about data theft. It is not just about a data breach. It could be as simple as software obsolescence. A software gets outdated and something you could open with Adobe whatever version no longer opens in the newer version. And you no longer have that old software also functioning now. Then what do you do? So when we are talking about electronic evidence in courts, and that's why I asked you all to keep those parameters which the model law talked about, and you look at 63, and you look at how we are going to deal with the electronic evidence, you will realize the complexities involved with not just one certificate, but two certificates, both of which are not going to solve your problems, unfortunately. Right? So that's why I gave that one example. Next slide, please. So let's also look at some solutions. Don't worry, I'm not going to leave you all too bleak also, okay? So processes are something you can, next slide, please. Processes are something you can definitely take it into account. But decision making. If you're going to substitute AI for a judge, is it really going to work? You will read a lot about AI judges and, automated decision-making processes. As you can see, multiple jurisdictions are working on it. But how effective do they find it? And where does the buck stop in terms of using AI judges? The Estonia example I've given already tells you about the one thing which is critical and which I've been repeating often in today's session also, the necessity for human intervention. By all means use technology, but don't take the human out of the cycle. The human will still have to be there to evaluate what technology churns out. Then it may be a safe bet. But to just substitute technology for human intervention is definitely not just going to impact justice delivery, but our very fundamental rights itself, right? The next slide, please. This is a classic case, which now you all may have heard of quite a bit, but it still emphasizes one of the most important aspects. Now, Compass was pointed out to be AI, afflicted with AI bias. And Compass was used for predictive sentencing. Will a person commit an offense again? So, if he is a recidivist, then should we give a stronger sentence? Or can we use lighter sentences? Now we have community service, for instance, right? Can we just give community service, or should we make it the highest possible sentence under the Bharatiya Nyaya Sanhita, right? So for deciding that, if a compass is used and if it is afflicted with bias, now it chooses a particular community and goes by race, color, etc., and says, no, he will be a recidivist, so let's not let him out too early, give him the most, heavy penalty possible. And if you are Caucasian, for instance, and it doesn't give you the same punishment, then you already know that the very basis of justice delivery has been tainted, right? So the issue that then was in the Loomis case was, should this be struck down, the use of compass, as being unconstitutional? Interestingly, the courts upheld the use and held it to be constitutional, but with a qualifier, saying that only compass cannot be the basis for sentencing. The judge still has to apply his mind, the human in the cycle. You cannot take away the human behind the wheel. I call it the human behind the wheel because, interestingly, in many cases that come out of the US about autonomous vehicles or self-driving vehicles, as they like to call it, where the drivers were playing a video game, for instance, and lost their life because the AI could not recognize an obstacle. This was in one instance, it was a white trailer truck, which because of the sun reflecting off the white surface, the system did not catch it. And the car rammed into it, and the driver was not paying attention. He was playing a game. And he lost his life, and yet the human behind the wheel was held liable. It is not like the systems can say that they are not liable at all. But interestingly, the human behind the wheel was also held liable. And the courts have repeatedly held in the US that it does not matter whether it's an autonomous or self-driving vehicle. The human behind the wheel has to pay attention, has to still be vigilant like any other driver would. If there is an accident, otherwise they will be held liable. So why I'm mentioning all this is that it goes back to what I've been saying repeatedly, that you can use technology, but it cannot substitute. It also gives you all a lot of courage, right? You don't have to worry that your jobs are going to get taken up by AI. Can't happen, at least not in the near future. Next slide, please. Again, another example where France did a test run. They didn't just, release the system. They did a test run and they found the flaws in it, that it is not able to predict correctly. And therefore, they have shelved it. France has been very tough in terms of use of technology for multiple fronts. Before we were coming here, we were talking about the interesting aspect of, and most of the lawyers in the room will appreciate this, I'm sure even the judges will, about corridor gossip and its relevance. Okay? One of the issues that comes up, and it's not often addressed, is the use of AI in mapping judges. How correct or safe is it? Should you even be using it? What are the ills that go with it, right? Why I'm mentioning this is, interestingly, France has come out with a law which makes it illegal to do that mapping. So you cannot use AI for that. So you have a negative law also coming in to protect you against misuse of technology. So these are some interesting developments which tell you how a particular jurisdiction identifies an issue or concern with the use of technology in terms of cyber justice and also counters that through either laws or regulation. Next slide, please. This is something which I love. So that's one of the reasons I asked for the screen in front is so that where I want to, I could read. This is such a beautiful decision from our Supreme Court, and I would take a moment to read out these 4 lines. Should then our courts not advance with the times? Should they still continue to cling to outmoded concepts and outworn ideologies? Should we not adjust our thinking caps to match the fashion of the day? Should all jurisprudential development pass us by, leaving us floundering in the sloughs of 19th century theories? And please don't miss the year when all these words of wisdom have been said, as far back as 1986. We are not talking about AI then. We are not talking about technology as we understand it today. And as far back as then, the courts warn us about not being a dinosaur, not being that person who's too scared to adapt technology or to understand technology and who would just eschew it, would rather just leave it behind and continue in the way they always have. Then the times will leave us behind. The world is moving forward. They are willing to experiment. They are willing to try out new things. But as you saw from the presentation, you had certain jurisdictions going ahead very boldly. I always say one of the big techs uses this line, we would rather seek forgiveness than permission. So they will first launch, make their mistakes and say sorry then. If they have to pay the fine, they pay it. But they would do that, why? Because they would rather be the first of the block than wait to test it properly, etc. But you also saw the France example where they are testing first and then deciding. A lot of money would have been pumped in to create the technology for those e-code projects, right? And yet, if it didn't work, they were willing to give it up and did not just move forward just because money has been spent. So, I'm not for a moment advocating spend money and then don't use the technology. Spend money wisely. First, identify what is the technology you need. What are the pitfalls in that technology or the use thereof? Can those be countered? For instance, use of AI. A very simple example I'll give. In the context of even explainable, even in terms of generative AI. You could use explainable AI. There is a lot of debate on whether it really works or not, but that is a solution that is there. And explainable AI in very simple terms is, we always have this saying with respect to AI, where we say garbage in, garbage out. So if your data is tainted, that's where you have the Loomis situation, where the outcome is also tainted, because it was already tainted with AI bias, right? Where is the bias coming from? From the creator or the data that the creator has fed. So if you can control the data that goes into the AI system, and then thereby control the outcome, there is one school of thought which says that you can use that kind of an AI process even in decision making, but of course with the human oversight still intact. There are many more examples than what I've put here too for these kind of alternatives. So that's a solution. That's what I mean by adapting technology but with eyes wide open. The next slide, please. That's exactly what you have in the next slide. What better than a new Lady of Justice for that? Next slide, please. Now, we go to the second part of the presentation. So before I do that, please may I request you all to come up with your questions. It doesn't have to be about the portion that I've already completed. You can also raise your questions on what you would want to hear in the next half. Yes, please.
A very good evening to everyone. Ma'am, I just have a small question. Could you please define the word cyber and differentiate between cyber and technology?
Interesting. But that goes to fundamentals and to cybernetics, etc., the Greek origin, etc. But I won't go into that right now. But suffice it to say, today when we are talking about technology, I'll tell you from the context of my book instead of going into the etymology, etc. I was going to call my book Cyber Laws Decoded. And then I renamed it as Technology Laws Decoded. Because the way I looked at it was, technology is much wider. It also ties into what I told you earlier about law and cyber, right? About how we had civil, criminal, but cyber is a horizontal. Similarly, cyber may be a domain also, but technology is horizontal. So when you talk about the use of a digital domain in multiple verticals, let's say in medical science, for instance, right? Would you call a medical solution that has come up, let's say an AI solution, as a cyber solution or a technology solution? It is based on AI. So why shouldn't it be called cyber? Why do we call it technology, right? Because in terms of how cyber is adapted, how the digital domain, I would rather put it that way, even in terms of the use of the word digital, it's actually very complex. Because if you look at the 2000 version of the IT Act, it used the word digital. The 2008 amendments amended it to electronic. Why did they do that? Was there any reason behind it? Because we were freezing technology at a particular point of time, right? The domain is what you're referring to when you say cyber. Technology is the methodology through which it evolves in its implementation and application. The rest of it, if you want to know about the genesis of the word cyber itself, read my book, right? Anyone else? Yes, please.
Good evening. Good evening. My name is Lemons. I just have two quick.
You want to just tap and see? I don't think it's working. Can I have this water? Water
Good
is
evening.
fresh, no?
My name is Lemons.
Yeah, please go ahead.
Yeah, I just have two quick questions. One is related with the cost-benefit trade-off in case of adapting technology, which you mentioned.
Can you be a little bit more loud? I couldn't hear the first part of it. What is the first part of the question about adapting technology?
The cost-benefit trade-off, which we are discussing. So, most of the times, the technology adaptation, even in terms of the codes also, that is a one-time cost. For example, we take it the blockchain technology, and in case for that is to be the documentation, legal documentation purpose, we are using blockchain technology. The kind of enormous accessibility that provides is too huge, and that is forever. The benefit is forever, but most often the adaptation cost is only one time, initial installation of the adaptation cost only. So I just wondering, do we really need to consider the cost as a really prime facie kind of a...
Excellent question. Thank you so much for this. Because you have to remember some of the other aspects I talked about too. How long is a technology going to last? So if it is a long-term, if it is a marathon runner, then the one-time cost is valid. But blockchain, for instance, is not a one-time cost that is a concern. When you adapt blockchain, you develop a specific customized blockchain for your requirement. That is the one-time cost. Then its functioning is a repetitive cost. There is an operational cost. For instance, the permissioned blockchain will entail an incentive payment for the person who is verifying your block, right? So that is an added cost and a continuous cost. So there is no such thing as a one-time cost when it comes to technology. Then you have to evolve, keep evolving the technology, because obsolescence happens very fast today. How many, we know the number of years we used MS-DOS, right? The early day usage. Most of you all won't even remember it, but we used it for many years. Today, how many of you all use your phones for more than 3 years? 3 years itself may seem like a long time. What are you really changing it for? Because a software update that happens then slows down your system. And after some time makes it obsolescent, right? So technology is never stagnant. There is a cost that will be there as a continuous cost, but that itself should not be the reason for not adapting technology. Like I told you all earlier, what is the benefit? It won't just be cost benefit, but you will also take into account the socio-economic, socio-legal aspects. So when we talk about cyber justice, we don't only look at the cost. Would you shut down your courts because they have become too expensive now? Justice delivery is an inherent part of a societal framework. So you would not stop a justice delivery system because it's become too expensive now. Same way, adaptation of technology is never just about cost. What is the benefit it brings to the stakeholders? How can this benefit be given in the same way with the same effectiveness without this technology? With the technology, if the effectiveness is better, then what else do we have to look at? That's where the risks and threats and vulnerabilities become relevant. If the risks and threats can be ring-fenced, protected against, then you would still go ahead. But remember this, one of the quotes I've used in my first book is of Kaffenberger's, and he says there are only two kinds of systems. One that has been hacked and one that is waiting to be hacked. Okay? I changed it and I said that there are only two kinds of systems. One that has been hacked and the other has been hacked, you just don't know about it. You're waiting to discover that it's been hacked. So you have to understand that when you're adapting technology, the risks are inherent in it. Threats are bound to happen. That itself also doesn't stop you from adapting technology. That's when the third aspect comes. We talk about prevention and protection first. The third is the most important, which is your speed or your resilience. How quickly can you bounce back when you have an attack? So just because a problem is there, we don't avoid a solution. We find what the other alternatives are and we find solutions for that solution also, right? So resilience is something every cyber system builds into it. Processes for a cyber system build into it. Okay, so it's not as simplistic as a cost effectiveness. That's only one aspect of it. Yes, please. So, वो पीछे दे दीजिए. हाँ. दे. Did you have one more question?
I just had.
After
Yes,
he
yes.
finishes, you'll have to now wait.
My name is. Hello, my name is Shiv Shankar.
Maybe you just have to hold
Hello.
it higher.
My name is Shiv Shankar. I'm from Bengaluru Law College student. See, I'm going through some of the blogs where I understand some artificial intelligence. They call it it's an plagiarism instead of.
They call it what?
A plagiarism. Because,
Plagiarism.
yes. See, the term, whether we can use the artificial intelligence itself or now the discussion is going on in the social media platform. And in India, what I observed is the plagiarism itself, we are considering plagiarism IPs, intellectual properties. They're considering their own IPs. They're giving for plagiarism. That's.
Yeah, I have understood your question. Just for the benefit of others, I'll just repeat the question and then give you the answer. Very interesting question. Thank you for it, because it's very contemporary also. The question was, is AI encouraging plagiarism, and does it impact IPR, intellectual property rights? Absolutely, and in fact, many celebrities have now come out also to contest this. By the way, OpenAI is facing multiple litigations in the US. US has always been ahead of the curve in terms of coming out with cyber jurisprudence. So some of the cases we are waiting for an outcome on is this OpenAI cases, where particularly news media outlets have sued OpenAI. What is their case? That you are plagiarizing. Here it is not just plagiarism, according to me, copyright violation. I have explained it in multiple fora also. I'll just give you a brief input on that. Now, I have my CyberSathi website. It is content heavy and it gives you a lot of information, right? I also have a licensing term built into it. I give you the copyright to access the site and to read the information and to put it to your personal use. So if a company decides to do a corporate training and they use the content from CyberSathi for that corporate training, that amounts to a violation of my copyright. Or rather, CyberSathi's copyright in it. Okay? It's as nuanced as that. So imagine you building an AI using that data, and the AI then giving out answers which are effectively reproductions of content which is in someone else's site. So would that be just plagiarism, or would it be a copyright violation? It would depend on the terms of usage of the platform from where that data is collected. So if the platform allows you to use the data for whatever purpose, then it is at best plagiarism. But if there is a very clear restriction saying you can only use it for your personal use and not for any commercial use, and if that is used for feeding data to develop an AI system, or for the AI system to use crawler technology to learn and build on it, then that amounts to a copyright violation. So the issue here is not about, therefore, throwing the baby out with the bathwater. Nobody is saying stop developing AI. What it means is, if AI is going to use content which belongs to someone else, there is a very simple solution in intellectual property rights laws itself. Pay a license fee. That's all is mandated. So depending on the use you put a particular data or content to, you will have to then meet the requirements that are mandated by that particular platform. Now, it can actually evolve into a lot larger as we go forward. There are government sites which clearly say you cannot use crawler technology. Okay, so for instance, if you're culling personal data out of a government website where that data may be available for public viewing, and you develop an app and you're selling it by saying, I provide you these services. Oh, you want to check somebody's land records, I can do it because I can have access to this thing, to the government site where I've culled out all this data, I have analyzed and I've put it together. That is my sweat of brow here. And therefore, this is my product which I'm giving to you, etc. If that government site says, no, sorry, you cannot use crawler technology to come and view it, then that itself may be a violation which goes beyond just IPR. At the very least, it's a contractual violation at the higher level, depending on the laws that are applicable. Today, if you look at the DPDP Act, for instance, it does not have a criminal provision. Perchance, if it had, and you have violated somebody's personal data through this crawler technology, you could have even faced criminal prosecution, right? Depending on what the act is, therefore you will see certain penalties on it. So this is where we stand today. It's really very interesting to wait and watch where the OpenAI cases are going to land now. So maybe we'll take one more question and then we will move into the second part. Sir, please. Of course, I cannot say no to the first benchers though.
Please correct me if I am wrong, madam. 63 of BSc and 65B both say subject to the conditions, complying with those conditions would make that certificate admissible in evidence of contents of the original. Would it be still necessary to prove?
Yes, 100%, because if you look at the wording, 65B wording has been copy-pasted into 63 in that aspect. I can't give you the citations now, sorry, I don't have the memory of my senior now, I guess. But you have at not less than 3 Supreme Court judgments which clarify the word contents of the original, which says that it only talks about the integrity of the contents, not the truth of the contents. What I clarified, if you remember, is the truth of the contents. So let me give you a simple example, which is what I always use to explain this proposition. Now, I have already been told that I am an expert in cyber law, right? I know everything about 65B and 63. I know how to ensure that I comply with 63 in full, right? I send you an email and I say, you owe me 1 crore rupees. And I will prove that document perfectly and the document will get admitted into evidence. Does it mean you owe me 1 crore? That's the distinction I'm drawing here. So that the email was sent, that it contained the sentence, you owe me 1 crore. That is all is proven with 63. Whether you actually owe me 1 crore or not is the truth of the contents that we are talking about.
One more question.
Please, sir.
Now 63 contemplates 2 certificates. Certificate from an expert also.
Yes.
Is it practically feasible?
Not at all. Not at all. That's why I said not at all. Sorry, I almost, because you can see the anxiety in me that I preempted you completing the question also. Pardon me for that. See, practically it is not possible for the first reason that computer output is still defined as a printout. How can you generate a hash value for a printout? Are you then doing away with the printout as a computer output? Are you doing away with the printout as evidence in court, right? If you're going to give a printout, then what exactly is the hash value supposed to be of? Is it supposed to be of the original or the copy from which you're taking? Can a copy be taken from a copy? So many, that's why I always say, stick to first principles. We would not allow a photocopy of a photocopy. We would allow a photocopy from an original, right, in terms of chain of custody also. So similarly here, if you're talking about a computer output, you're really talking about secondary evidence. You're trying to place it at a different level than any other secondary evidence. And the assumption when 65B came was that it is actually supposed to make it easier. Why? Because you can't keep expecting a Google or any other big tech to answer to your notices for notices to produce. If you're relying on secondary evidence, just to give you one example, right? If you're relying on an email, will Google come and give you a notice to produce from their server, output taken from there, etc.? You would rely on what is available to you. That was the criticality of subsection 3 there. Okay. Therefore, it was supposed to be an enabler. That's why I mentioned earlier also about law and lawyers being obstacles rather than enablers, right? Today, law is supposed to be an enabler. But is the question when it comes to 63. Time and again, it has been held that it does not further the requirement of proving integrity of a document, which was what I talked about earlier. What does it really prove? It just proves what a person claims to the best of his knowledge. That's it. So where is the level of threshold of evidence we are looking at, right? So that's where the problem is. What was thought of as an enabler, firstly was not an enabler because of the wording, and I'll mention that in the second part briefly. And the second problem that happened was, you please see the elaboration in Arjun Pandit Rao. Again, I'm jumping the gun, but I'll jump the slide later, it doesn't matter. Arjun Pandit Rao, the main judgment, clearly said, please read the English law from where you adapted 65B. The PACE Act as well as Section 5 of the Civil Evidence Act. Both were repealed before the 2000 Act came, the 2000 IT Act came, before. 1999, they repealed it. However, we continued with the same wording and in a more convoluted manner in our law. And we had the opportunity, not just from the English precedent, but also from Arjun Pandit Rao and all the other problems that the Katina of Judgments before, from Navjot Sandhu to Arjun Pandit Rao said. And yet we went ahead with 63. And I've given you a very brief input on that. But normally, if it were a training session, I have slides which show you where the changes are to show how cosmetic it is and how the ails or the problems of 65B continue forward with more complications, not less. And the addition of the expert's certificate with the mandatory requirement for a hash value being one of the biggest complications there. So the next slide, please, sir, please.
The section 57 of the new
Has
Act,
included electronic evidence.
there is one explanation 4 to 7.
Yes.
Those explanation, to some extent it solved, but not fully.
The problem is they talk about, they have included electronic evidence there, sir.
Correct.
And they have also, so I don't know if I retained those slides, but there is also a slide which I would have normally where you will see they have included evidence definition also now in BSA. So they have included electronic evidence in secondary evidence, but they have retained 63. So what that means is you may have a reference to what amounts to evidence and electronic evidence there, but you will still have to, when it comes to admissibility of a document, you still have to comply with 63. To that extent, Arjun Pandit Rao and Anwar versus Bashir will continue to apply.
Continue to apply, but the second judgment in Arjun Pandit Rao, the judgment in the second half, it says it is the law as of now. It has to change and it will change.
But it didn't change.
That is what it says.
That is why I said very loud and clear the Supreme Court said, sir, wo kaam nahi kar raha hai. Just check that, please. I think there the angle needs to be changed.
For the time being, it is the law now. And we have to follow because it is the law.
Correct.
That is what it says.
But unfortunately, considering that 65B has carried over, would Arjun Pandit Rao not still apply? And to what extent will it apply? And if Arjun Pandit Rao doesn't apply, doesn't it create more complications in terms of what happens when a service provider refuses to give you the certificate? To some extent, at least Arjun Pandit Rao gives you a solution there. But even that then remains negated if you say Arjun Pandit Rao doesn't apply.
I think what we have to take from that is that it only solves the first level, that is admissibility and the relevancy. That part, I think that can solve, but not about the proof. Proof has to be
absolutely
as required under law, because proof is an outcome of all the evidence put together.
Yes.
So, I take an example of a will. A will is produced in the court. It has been marked. Simply because it is marked, it is not proved. And the witnesses have to come, and 68 and 63, that has to be followed. Only then we will comment on the proof. But the one word which was there in 65B earlier, and now also it has been copy-pasted into 63, is that without any further proof. That phrase, that is causing the problem.
Correct.
For our all thinking.
Correct. But there only you will get, one is the older Supreme Court judgments on general thing, where certain laws use the same wording, what Sir had read out. And you have one judgment from the Bombay High Court, Jaimin Jewelry, which clarifies this issue. That only to the extent of admissibility, 65B goes. Thereafter, you still have to prove the truth of the contents. So that's one judgment that is still there till date, sir. I can share the citation with you later, but it's Jaimin Jewelry judgment. Okay, now we move to the second part. You just hold your question. I'll take it after we finish this part. I'll definitely take a few questions. If you want, I can sprint through this aspect. There were two things I wanted to achieve with the second part. One is, what do we see as the role of judges when we talk about the cyber domain or in terms of technology and law? The second thing which I wanted to emphasize was, we keep often talking about US jurisprudence. It's not like India doesn't have its own jurisprudence. So I wanted to draw on some of the Supreme Court judgments to show you how certain aspects of cyber laws have evolved. So that's the second part of the presentation. So this is again a quote from my book, which I really love because it's very evocative. I usually have a person actually driving a car off. I thought that looked too scary, so I changed it to a nice gentle parachuting, you know. But would you, there must be a lot of Formula One, fans in the room. Would you drive, forget about a Formula One car, would you drive any car without brakes, right? So law is supposed to be those brakes. The brakes are not meant to be a restriction on your exercise of your rights, but to protect you when you're exercising your rights. And that's where I keep repeating that law is an enabler and not an obstacle. Next slide, please. We'll go a little fast now so that I can address more of your questions then. But I just wanted to put this case first. I had the privilege of being associated in this case as amicus, and think about it, 2017 when nobody was talking AI, the Supreme Court took this issue up and an order was passed in October 27, 2017 for developing AI to protect women and children online. So the case was quite horrific. It dealt with horrific issues such as uploading of actual rape and gang rape videos online on social media platforms, not in the darknet, not in some hidden corner, but on social media we use every day. And sadly, the first time I came across this case was when I was researching for my first book. And I just, as a criminal lawyer, I could not believe that criminals were uploading proof of their crime online themselves. And one of the NGOs which was involved in it mentioned about how when they were it is really sad if you are constrained to watch these videos. They had to watch before they forwarded it to the Supreme Court. And they said in one of the videos, the person is actually upset that his face is not showing properly. This is the level of depravity there, right? And when the victims wrote to the social media platforms, the content was not taken down. When the NGO wrote to the platforms, the content was not taken down. So the NGO sent a letter to the Supreme Court, to the Chief Justice of India, along with a few videos, and it was taken on board as it was taken cognizance of as a suo motu criminal writ petition. That was in 2015. Fast forward to 2017, the issue of child sexual abuse material online, or what we used to call as CSAM earlier. Now the Supreme Court has added an E to it of exploitative also, CSEAM, and that became part of the scope of the matter too, and I was appointed as amicus to evolve possible. I'd suggested the use of AI, and the Supreme Court took a very strong support in terms of evaluating the possibility. A technical committee was appointed, and this was a consensus-mediated process. It was not adversarial. So everyone came together, government, big tech, civil society organizations, everything came together, and the consensus proposals became an order of court. One of the consensus proposals was for evolving an AI solution, which at the time of upload, so when you upload, it lands on a server and then gets distributed, but the lag is very short, the time lag, right? So, but between that, can an AI solution be deployed to stop that from being distributed to public? Now, the solution proposed by the Supreme Court in 2017 has now become a reality. So, you now have a substantially high percentage of filtration even at the stage of upload. So, many victims, it's a very victim-centric solution in that sense. Why I wanted to put this first was we have talked about AI last, and here is a positive way of using technology too, right? That's why I told you all, it's not all bleak when you talk about technology. There are so many good things you can do with it too. And this was a classic case in terms of positive use of technology. So during COVID time, when a lot of misinformation was happening, today when you are faced with hate speech and false information or fake news, this is the same technology which was then developed for protecting women and children online, which is now being adapted to protect against hate speech, misinformation, fake news, and a lot of other problems. So this is how the intersection of law and technology can work and work positively, right? There are a lot of other things also which have happened that way. You may have heard of the site where you need to go to file your criminal complaint, cybercrime.gov.in. That came out because of this case. See, many things about this case may not be visible because we did it in a very low-key manner because the outcomes were more important than visibility. But the outcomes were substantial. So the first time when cybercrime.gov.in was launched, it was only for offenses against women and children. But they called the site cybercrime. So it needed to be expanded and they did it. So today, that's why when you go to the site, you have two categories. You have a separate category for women and children and a separate one for other crimes. This is because the genesis was from a situation like this. So we are just talking about a couple of things, but there were many, many more. I have seen both sides of it. One, of course, was as part of this case. One of the things that came out was an MOU with an organization called NCMEC in USA, where all the technology companies submit child sexual abuse material to. Then they figure out how it can be prosecuted and also protected against future uploads, etc. Now, as an advisor at that time for Maharashtra Cyber, I was on the other side advising them in terms of the implementation process. COVID happened, I don't know what would have happened otherwise, but within just a short period of 3 months, they apprehended nearly, I think if I'm not mistaken, 400 chat apps. So we are not talking about 400 people because at that time each group would have 6 members or so. They were able to apprehend, thanks to this one development from this case, several thousand predators, pedophiles, within just 3 months. So that's the impact that one case can have. And India led from the front. At that time, during the same time we were arguing this case and we were still evolving solutions, I made a brief trip to the US and I was shocked to hear somebody talking about the same issue there of the uploading of violent videos against women and child sexual abuse material, etc. We did. So this is something that you have to keep in mind to see how law can be used in a very positive way. Next slide, please. So next slide, please. I'll talk about that briefly. The slide I skipped. But suffice it to say that if you now have your intermediary guidelines of 2021, that substantially adapts a lot from Prajwala matter. They mentioned it also when they released the draft. And particularly, it adapts this aspect of a voluntary process of deploying AI to block this kind of content. That's a direct outcome from Prajwala. But there were many other aspects too. One most important aspect is we had this vexing problem of what is called colloquially as revenge porn, but I prefer the word sexploitation because revenge porn somehow makes it feel like you're blaming the victim. You know, you're kind of like diluting the harm that is being caused to a victim, right? It's exploitation. So you have videos or imagery that has been consensually taken and thereafter being misused through extortion, and that's what was not covered under the scope of Prajwala. But the solutions that evolved from Prajwala's matter became relevant in terms of protecting against these kind of cases also. One of the most interesting initiatives I've been part of is over the last 2.5 years, UN has been evolving a new cybercrime convention. Now, one of the provisions they have proposed under it will protect not just against CSAM and violent imagery of women, etc., but also against revenge porn. So we'll have to see whether that's going to get adapted in a gender-neutral way, because it would be very myopic to think that only women are victims. But there are enough studies which show that we do form the softer section, more amenable to harm than others, and children. And the other section which is most often ignored are the other genders. They are much more vulnerable also sometimes than women, because many of them may not want to express their sexual preferences to the public. So they fear being outed, as they say, right? So it is their choice whether they want to come out or not. But if that is going to become a basis for being exploited or extorted, then that also should be taken serious note of. And clearly, of course, it's a crime, but we just don't get enough examples of it, because not enough people come out to file cases on that. So that was something that was another aspect I had put in the second slide. Now, this is where, in a way, it all started. 2015, when you had the Shreya single judgment, which struck down 66A. Interestingly, till today, you still have cases being filed under 66A, and the Supreme Court has repeatedly come forward to say, issue advisories, issue notices, and make sure that it is not abused. But it becomes an easy solution to stifle certain kinds of speech and certain kinds of times, and therefore it still gets adapted to. But it was a very interesting case, and till date, whenever you are evaluating intermediary liability, the Shreya single judgment becomes the benchmark for deciding where and in what manner intermediary liability should be decided. Keep in mind, this is a 2015 judgment, because there is a very interesting development I would have covered through another judgment later. Next slide, please. Puttaswamy judgment, I don't have to spend too much time on. Just wanted to say how critical it was, and to emphasize that it did not give us the right of fundamental right of privacy. It acknowledged that we have the fundamental right of privacy. That's a criticality, because often people tend to forget that we had the right to privacy before Puttaswamy also. It's not like they could take it away before that and they had to give it only after. They always needed to give us the right of privacy. It's just that they probably didn't know about it, but now they know. The importance of this may come up, but we'll have to wait and see how it is going to pan out, because you have a case that is pending before the Supreme Court, especially about the WhatsApp change of privacy policy. That's come up again because of the CCI judgment recently, but we'll have to see what the Supreme Court is going to hold, and that's where my worry is in terms of the wording of the DPDP Act. Because when the case was before the Delhi High Court, the government took a very strong stand that WhatsApp should extend the same level of protection for giving us an opt-out. An opt-out for the European Union is not to be deprived of a service. It is an opt-out of the sharing of data, but continuing with the service. So if you can give it for jurisdiction A, you should be giving it to jurisdiction B. But that was before the DPDP Act. But today, when you look at the wording of the DPDP Act, it still does not really capture the opt-out provision. Can they include it in the rules, and how are they going to do it within the remit of existing law? That is something we will have to wait and watch. The next slide, please. This is the judgment I told you all to remember, the 2015 date of Shreya Singalan. I don't know how many of you all remember the complete chaos that happened when the CEO of a site was arrested for content that was hosted there. This was the Delhi MMS case, where a video was being sold on the Bazi.com site, and the CEO was arrested. So if a single instance can actually change the law of the land, it is definitely critical. In the Anita Hadda case, the prosecution against the CEO was quashed. But the bigger outcome that happened because of this case was Section 79 was redrafted. Many people forget this has happened itself, because the section as it stood before 2008 amendments put the onus on the platform owner to show or to prove that he did not have any control over what was the content shared and to whom it was shared, etc. It was only after 2008 Safe Harbor was incorporated into Section 79 the way you see it today. And that got emphasized with the Google versus Vishaka case, which I have mentioned here. This is not the original Vishaka judgment you're talking about. This is a case which pertained to intermediary liability. The next slide, please. The Sharad Babu Digmarti's case also came out of the same Bazi.com case, where there was a CEO of Nish Bajaj. There was also a manager, Sharad Digmarti. Now, one was quashed and the other case continued. And what happened with the other case? 67 was quashed and then a prosecution was initiated under 292. So the court said where you have a special provision, then general does not apply. And where a quashing has already happened under the special, then you cannot now convert it to the general law and continue the prosecution. And that's a critical aspect because one interpretation that came from it was in a Bombay High Court judgment where it also took the same thing. Anwar versus Bashir also says it, and again that's first principles. Special will always overrule the general. But it should be apples to apples. Here 292 to 294 IPC was the same as 67. 67A is a heightened level of 292 to 294 IPC. So here you can't quash under 67 and then apply 292 was what they said. In the Bombay High Court judgment in Gaurang Sharma or G. Sharma, I don't remember the first name. So in that, what they say is that they compare it as if it's a whole, totality. Where IPC provisions are there and IT Act has provided for criminal provisions, you cannot then apply IPC provisions. There it went beyond 67. 67 IT Act, for those of you who may not know, talks about obscenity, and 67A is a sexually explicit act. 67B talks about child pornography, which is now renamed as CSAM with an E. So when you talk about replacing entirely, it cannot be sections which are not provided for under IT Act. And in that case, there was a reference to breach of trust, cheating, etc. So whether that could be the case became the issue. That was not appealed, but a subsequent Bombay High Court judgment has clarified that. Apples to apples, special overrules general, but not beyond that. You cannot just completely set aside a general law only because a special law provides some provisions. Only to the extent of those provisions you can replace it. The next slide, please. Sabu Matthew is very interesting because, again, we talked about the use of AI. So whenever you do a search on any search engine, you would see that you would start typing and it will give you a suggestion, right? So the issue was about, can it give a suggestion for a PCP and DT test, which is illegal in India. So again, technology in a positive way. The big tech companies undertook that they will limit the search options, the auto filling as they call it, such that it will not give this suggestion for doing a PCP and DT Act. So that's why I listed this aspect too. The next one, please. Now, we talked about technology and pros and cons. We also talked about fake news and hate speech, etc. We went through a whole phase where fake news was causing harm to life and loss of life. Mob lynchings. Individuals being killed because of this fear of child kidnapping. So the problem is it's not just limited to online platforms. Chat apps become the easier way of accessing. Then what happens? How do you deal with it? The next slide, please. So Tehsin Pulavana and Kodangalur dealt with the same issue, but from different perspectives. One was the mob lynchings, etc., what I talked about, the child kidnapping cases and whatnot. And Kodangalur is in the context of the Padmavat case, where they talked about how mob frenzy can be encouraged through the use of social media and the harm caused because of that. Now, when you look at this with the next slide, please, with the next case also in this similar fashion, the Alok Srivastava case was during the COVID lockdown. The issue about the migration workers, right? And what is the harm that is being caused to them. So when the PIL was filed and the government said, no, we are cognizant of it and we are already taking care of it, the court refrained from passing any order in respect of the prayers. But the interesting thing that comes out of this case is social media is equated with legacy media, print or TV, etc. And the court warns them about distributing fake news or hate speech and to take action. This is what I meant when I said, you know, the reason why I mentioned about the positive aspects about the Prajwala cases, and I have spoken about it. If you want, you can go and listen to it later also. But very briefly, whilst I was arguing about the use of AI for protecting against abuse or for victim rights, for protecting victim rights, there was a concern also about restricting free speech. Can the same solution not be used to limit free speech? Can it not be used for filtering out data that you don't want out there? Can it not be used to stop me from saying what I want to say? Definitely it can be. But does that reason enough to not use a particular technology? Right? So that is the dilemma that we are always going to be faced whenever we talk about technology. That also answers the question one of you raised about, and what I told you, it's never just about cost. It's always about multiple parameters, right? So when this and the other two judgments gave directions in terms of what is the responsibility of a platform in terms of fake news or hate speech, ultimately it all boils down to only one thing: how quickly can you take down content? You may not be able to control always. Even with the filtration process I talked about in the context of Prajwala is called as active filtration, where you already know the data which is harmful and which is online, and then you're asked to remove that. That's called as passive filtration, right? So active filtration is, you know, in real time, where you're able to identify and block, etc. So when you're talking about filtration, that is just one aspect of it. You may not be able to filter everything, and if you try to filter too much, you're going to stifle free speech. So the balance is how quickly can you act. And in that, it's not just India. After the Prajwala case, you have instances from the US, from Germany, from UK, giving directions to social media platforms to use AI to identify, to remove, to identify, to warn. So for instance, one of the platforms would give you a warning if your message is deemed to be a fake news. It appears it may be fake, please verify and remove, kind of thing. So they were balancing the free speech aspect by not removing the data, but by giving a warning. And when someone comes to forward that message, they will be given a warning that you may not want to forward it because this has already been identified as possible fake news. So those were all methodologies which were technology enabled. And the directions that come from these three judgments also went a long way in terms of how social media responsibilities evolved, and a substantial part of it now forms part of the intermediary guidelines of 2021 too. The next slide, please. And this again also goes to show how precedent law can formulate or evolve legislative enactments. Unfortunately, that didn't happen with 63, as I already said, but that's a story for another day. Now, Anuradha Bhasin's case is again important, because when we talk about free speech, and we have a judgment coming from the Kerala High Court, which unequivocally says that your access to the internet also is a fundamental right, and we talk about internet blockages. And here was a case where it used 144 CRPC and a temporary suspension regulation from the Department of Telecommunication, right? So the courts very unequivocally held that temporary means it is supposed to be temporary. But here is where there is a balance and a restriction or restraint that the courts have exercised. So in Anuradha Bhasin, the court stopped short of taking action in terms of reinstatement or otherwise. They left it to the sensibility of the executive to evaluate and to reinstate, saying that it cannot be permanent. It can only be temporary because that's what the law itself says. But importantly, one of the aspects that comes out is in terms of not just the freedom of press, because that was a ground that was raised by the petitioner, but claiming a restriction on your freedom of speech or for that matter to profess your profession because somebody stopped you from doing it, and claiming it because you are inconvenienced and therefore unable to pursue it are two different things. Here, what the petitioner said was that because of the internet blockage, I am unable to exercise my right as a journalist. I am unable to print what I... They said there is no restriction on your printing or sharing your information. Where it is transmitted, how it is transmitted is what is different, right? So that was another criticality that came out of it. Again, the distinction between digital and print also comes out in the context of spread and depth and width of sharing of information. Next slide, please. Something very interesting for many of you maybe. Now, there was a myth that was being spread that cryptocurrencies were banned in India. Unfortunately or otherwise, till date, India has actually not taken a stand with respect to cryptocurrency at all. They are still evaluating. What happened in the middle was RBI issued 2 circulars saying that banks and payment systems should not transact in, with respect to crypto assets. That was all they said. Now, in the IAMI judgment, interestingly, the first part clearly gives, see, this is the problem. When a court gives you guidance, when it is telling you, you have the right, please do something with it, the legislature has to take the ball and start running. If they don't, then they have really let the ball slip. And the victims will be us, who rely on the pillars working effectively. So, similar to the Arjun Pandit Rao judgment, in the IAMI judgment also, the Supreme Court gave clear direction to RBI saying, you're wrong in saying you cannot regulate, because the RBI stand was, I can regulate banks and payment systems, but I cannot regulate crypto assets. But they said, no, crypto assets are also a payment system, so you can regulate it. But they didn't take that up. The second thing that it said was, it rejected almost all the grounds that the petitioners raised, but on proportionality, they succeeded. That the courts felt that RBI circular was disproportionate in terms of an complete blanket ban on use of banks or payment systems for crypto transactions, and therefore the petitioners succeeded. I do have a slight variation in terms of that because I felt that where relief 2 or 3, which was about can a company or an organization come before a court under, say, Article 32, was rejected, saying, no, you cannot come, then how could the last part be allowed, right? Because once the maintainability went, then everything else goes. But anyway, that's on an aside. But the interesting aspect that comes up with this is the part which I already mentioned, that the courts gave clear directions to the executive on what they could do, and that still remains to be done. We'll have to wait and see what is going to happen. The next slide, please. I'll rush through this. The next slide, please. I'll cover all this in Arjun Pandit Rao. I know it's been a long day. Next slide, please. But just read the case laws. This is the reference. The next one, please. Next slide, please. Yeah. So now we talked about Arjun Pandit Rao. Now this is just a summing up of what happened in Arjun Pandit Rao. Interestingly, why I wanted you all to just pay attention to Shafi Mohammed is, Anwar versus Bashir was very simple. It only said, if you are producing an original of an electronic record, no certificate is needed. That's exactly what the law says. It is the same situation under 63 also. But if you're relying on a secondary evidence, what is referred to in the section as computer output, then the certificate is mandatory. So Navjot Sandhu was overruled because that said you may produce the certificate or go under 63 or 60 and 65, right? So that's the only distinction there. Now Arjun Pandit Rao affirmed Anwar versus Bashir and said the certificate is mandatory, and it overruled Shafi Mohammed. Shafi Mohammed was a 2-judge bench. So what they did is they did not overrule Anwar versus Bashir, they could not have also. But they distinguished and said Anwar was perfectly right, but where you're unable to produce the certificate because the service provider is not giving it to you, then you can apply to the court. The court can call upon the service provider to give it or dispense with it. So when you look at what Arjun Pandit Rao does, it is not very different from what Shafi Mohammed said. But it overruled Shafi Mohammed. At the same time, in the Arjun Pandit Rao case itself, where the petitioner had already issued the notice for the 65B certificate and the service provider had not given it, the court said it can be dispensed with because justice should prevail. So effectively, what they did was similar to what Shafi Mohammed said, but Shafi Mohammed was overruled. Then they also went on to say, and that's where I have a bit of a concern, a 65B certificate is not an existing document. It is a certificate about an existing document. So there cannot be a notice to produce that document, which is the 65B certificate. You can at best issue a notice to produce the original document, not the certificate. That distinction is missed out in Arjun Pandit Rao. So that is an aspect, again, which is not addressed in 63. But there are two things that Arjun Pandit Rao said, which is supposedly addressed in 63, but is not. The first is, when do you produce the certificate in a criminal case? It says preferably when you're seizing the documents itself, but definitely before charge sheet is filed. In civil cases, it says at the time when you file and rely on a document. That's what 65B4 said actually, that you have to produce it at the time when you're relying on it. Now, when you look at 63, it's very interesting. Next slide, please. The wording used is submitted for admission under the new correction, in 63. What do they mean by submitted for admission? Could they not have used more specific language? So when you look at 63, first, what are the changes it brings about? It adds about the communication device being part of it. It also adds the semiconductor memory, etc., being part of electronic evidence. Then it brings about substantial change in subclause 3, which is actually critical because it simplifies what 3 is supposed to do. Effectively, what subsection 3 did is, it clarified that when you're dealing with a standalone computer, when you're dealing with a network of computers or a system, then everything is deemed to be a single computer. So wherever you take it from, it is still an original. It's a copy taken from an original. That's how it was supposed to enable relying on a secondary evidence. That wording, which was very complicated in 65B, has been simplified in 63. But if you look at 63.4, it remains the same as 65B. It retains the same problems as Sir rightly pointed out. The first part of 63 also retains the same wording with respect to the proof of the document, etc., which could have been addressed because these were issues already raised, but they have not been addressed. There are other issues also. Now, when you look at the first part of 63, same as 65B, it says you have to prove the computer output as per subsection 2, whereas the certificate is to be given as per subsection 4, right? So when you're doing it as per subsection 2, it has 4 subcategories. Each of those have been retained. Anwar versus Bashir as well as Arjun Pandit Rao interpreted it that all 4 have to be complied with, the conditions. In addition to that, there are 3 conditions in subclause 4. The third condition is complying with subclause 2. So technically, there are 2 more conditions. So both of these judgments also interpreted it that you have to comply with all 6 therefore. Whereas if you read 4 and the wording remains as is now, the first part says if you want to give rely on the computer output, you have to prove any of the following. And in subclause 3, any of the parameter set out in subclause 2. And that remains till today. But we still now have to probably apply on Arjun Pandit Rao and Anwar versus Bashir that any will be all over here, because there is no real alternative there. The addition, as we already discussed, of 2 certificates instead of 1 really confounds, because the entire debate pre-BSA was not about multiplying certificates. It was about whether the certificate itself was needed or not. And as Sir rightly pointed out, Arjun Pandit Rao, in no uncertain terms, clearly said there is no need for the certificate. Look, they did away with it in the jurisdiction where you copied from. There is no upside to it. So until such time as a new legislation comes, we are giving you some directions, right? But the direction that they gave was very clear: do away with this. See where the relevance is. Could 63 and 65 have been, or its equivalent now under BSA, have been applied or not? If you read the provisions, and now most of that remains the same, you would see that it can easily be applied for electronic documents also. Only the procedure would vary. As I said, the notice to produce will remain, etc. But that was the lesser of the problems we had in terms of reliance on evidence. Today, we have this complication in terms of the hash value, etc. And also, it is likely to create a much more complicated situation, because you have opened a Pandora's box in terms of cross-examination. I'm telling you, the cross-examiner is going to have so much fun. Now, they've also changed another word in 63, which is that the first certificate is given by a person in charge of. Earlier it said owner or administrator, now it is in charge of. So, how much of knowledge would a person in charge of a computer have with respect to hash values? Because his certificate also has to reproduce the hash value. Is it going to become a dream situation for cross-examiners? Only time will tell. Moving on, please. Next slide. This is like various digital assistants. If I don't tell the magic word, then the slide won't move. I keep using different words and then they don't move. So here we are, finally almost at the end of the road. Again, this was, please see the year of this case also, 1983. Such profound words, you know, so far back, giving us caution, right, in terms of how do we approach a situation where there are many challenges. Do we avoid the challenge? Do we meet it? And how do we meet it? We cannot allow the dead hand of the past stifle the growth of the living present. You know, wonderful words. Law cannot stand still. It must embark on its journey, right? So, the other aspect which they've talked about, the bark and the tree also, was so evocative. That's why I've kind of highlighted that. So I'll just leave you all with this slide to say that we have so many directional precedent laws that tell us what we can do and how we can go about it. It's now in our hands how we implement it. Thank you all for being such a patient and wonderful audience. I am, of course, here to answer questions as I promised. The last slide can come up. Oh, okay, it's gone to the first slide, but it's okay. Can you just move to the last slide, please? Yeah. The questions now, please. One of you had it. Again, not a question I'm going to take. The first thing is, I'm not a technologist, but incidentally, if it were a training session, I would have actually given you some guidance, right? So, but if you look at let me just address the legal aspect. The last slide. So, next slide, please. I finally remembered the magic words. I forgot that. Okay, so, yeah, we'll talk about that offline. Okay, but yes, if it had been a training session, I would have given you some guidance in terms of the calculation of the hash value. But keep in mind, everything came from cryptography, right? So the cryptographic processes, and what the law, that's why says is, if you look at the format they have given, they also ask you to clarify what is the technology used for generating the hash value. So you have your SHA1 thing, parameters, etc. So that aspect has been captured. Again, it is not frozen technology. It says like, if I'm not mistaken. So you are allowed to use others, and it is part of the schedule. So I'm assuming that will have more flexibility in terms of change. The rest of your question, we'll take it offline, if we have time. Otherwise, during a training session next time.
Namaste, ma'am. Audible? Yeah, ma'am. Adverting to the role of judges, we are concerned with respect to our privacy, with respect to adjudication or the breach of the privacy. It remains still on the paper. By virtue of a section 35 and 61 of IT Act and DPDP Act, the jurisdiction of the civil court is entirely taken away. So now the remedy under DPDP Act is the Data Protection Board. But however, section 43A of IT Act is violated. But there is no provision for breach or compensation to it. So again, it has to fall back to the civil court. So what's your take on that?
In fact, under the IT Act, you had a thing.
Adjudicating officer.
No. You had the adjudicating officer under 46, but you also had a cap on the pecuniary jurisdiction.
5 crore.
5 crores. So all matters which were above 5 crores still came to civil courts. The restriction was limited to 5 crores. That's how it was interpreted. But now under the DPDP Act, you don't have that pecuniary restriction. And as you rightly pointed out, and this has been one of my biggest criticisms of the DPDP Act, that you're talking about individual rights, but you're not giving them a compensation option. And you do have a penalty option, which is fairly substantial. And the penalty then goes to the consolidated fund. Then what happens to the victims of a data breach then? That is an issue that we'll again have to wait to see what the rules are going to provide for.
Indeed, it's my PhD research on that.
Oh.
So I'm playing a devil's advocate here. So there is an annexure which provides, section 33 provides for a schedule where the penalty is 150 crores, and that is to the Consolidated Fund of India. So in that case, the Data Protection Board has the powers of a civil court. In that, exercising the inherent powers, can it grant a compensation is again...
Now, that is precisely my point. Where is the provision for a victim to approach the board for compensation? Right.
As a data principle.
The data principle's right is only to file a complaint, not to claim compensation. There is no provision for applying for compensation based on harm caused.
So the difficulty is the victim or the individuals can approach the under IT Act nor under the Data Protection Act.
No, IT Act will now, 43A stands repealed. Once DPDP comes into effect, you would no longer have the remedy under 43A.
So individuals are not here, not there.
Not just that. There is another criticality here. 43A stands repealed, but not 72A. So you still have your right to file your criminal complaint for data breach under 72A.
Thank you.
After this, shall we limit it to 1 or 2 more questions maximum, if there are any? Yeah.
Good evening, ma'am. My question is concerning the accountability of perpetrators of cybercrime. Since in most of the cases, they are anonymous users. In that case, what substantial changes has to be brought in the present legal regime to tackle the same in respect of anonymous users who are who are the perpetrators of cybercrime?
Yeah, thank you for that too. See, actually, there is a lot of action already happening on this front. The first part is the please take your seat. The first part is the verified user aspect, right? Right now, under the intermediary guidelines, it is a voluntary process. Now, why it remains a voluntary process is the flip side of it again, fundamental rights versus, So, should my privacy be violated? Should I be allowed to remain anonymous if that is what I want? Or should I be constrained to share my identity data, right, with a corporate entity? See, often when we talk about privacy, we always focus on government and surveillance. I always keep emphasizing and focusing also on corporate surveillance, we tend to forget that that is a much larger evil sometimes maybe because it's consistent and continuous. Right? So how much of it would you really want to share? Today we are talking about how to protect minors' personal data. Now, how do you decide whether somebody is a minor? You first had the process of two-factor authentication, including through parental consent, etc. Right? But if a minor is creating fake IDs and using that for the two-factor authentication, who is going to be able to prove that? So then the issue, in fact, Australia has now passed the law for 16 and below not being allowed on social media. Now, how will they implement it? So for you to use social media, then are you going to have to submit an identity proof? Then you're giving much more information for corporate surveillance than what they will have when you just create an account. Right? So that's where the problems also arise and the balance needs to be struck. So and secondly, is the premise that you post first, is it true in its entirety? Are you really anonymous? Can you not be traced or tracked? So if you look at the one provision which is still pending for a decision, the first originator rule, the whole predication of that rule is that you can be tracked, whoever you are, because the platform still knows where to track you. So to what extent should it be allowed to track, and where is it tracking? How long can it track? That's the issue that arises then if the first originator rule is sustained. Right? Again, corporate surveillance actually prevails more than even the aspect of government surveillance. But of course, government surveillance is something we as citizens should be really cautious of. So the first thing that therefore to sum up is, people who are using online domains should not assume that they are invisible. They can be tracked, they can be prosecuted. Often it has been proven that it can be done. The difficulty is, how many times is it done? How much of illustrative cases do we have for it? If we are not able to show enough examples, then we are emboldening the criminal. The second aspect is, verifying an account is a good way in terms of preventing abuse of an account, but it also then violates a person's privacy and also exposes more of their personal data than otherwise. So the proportionality rule comes in. To what extent should they be asked to submit data beyond what is necessary for having a social media account? Last question.
Good evening, ma'am. Respected judges and my fellow law clerks and interns. My question is, can AI be used to protect a person's right to be forgotten from the internet?
The first thing is, we need to protect a person's right to be forgotten. It's more a right of erasure rather than forgotten. The second is the use of AI. See, what happens is, invariably people use AI to track and find what is the data that is there about them, and then they talk about whether that should be erased. So today it is a more of a process to find rather than the process of removal. Right? That's where AI plays a role in this. With that, thank you all once again for having me here.
The role of judiciary in the digital age is undeniably crucial. And we are truly grateful to Madam Nappinai for shedding light on the key areas where law and technology intersect. Thank you, Madam, for that insightful session. We would now like to extend our heartfelt felicitation to Madam Nappinai. Her insightful address today has been truly enlightening and inspiring. I now request Honorable Mr. Justice Sunil Dutt Yadav, Judge High Court of Karnataka and Governor Karnataka Judicial Academy, to kindly step forward and felicitate Madam Nappinai as a token of our appreciation for her time and expertise and invaluable knowledge. Thank you so much, my lord. As we come to the end of today's event, it is time to express our gratitude to all those who have made this event possible. To do the same, I would like to request our Additional Director, Shri K. Narayan Prasad sir, to propose vote of thanks.
Good evening. As we come to the conclusion of this enriching session in our Silver Jubilee lecture series, it is my privilege to deliver the vote of thanks. I would like to express our deepest gratitude to Ms. Nappinai for her enlightening lecture on pressing a relevant topic, cyber justice, role of judges in digital age. Madam, your profound insights into the challenges and opportunities in the digital landscape have left us with much to ponder and to explore further. Your expertise and eloquence have truly made this event remarkable. Thank you, Madam. In her ladyship's absentia, I extend our heartfelt thanks to Honorable Srimati Justice. Your Lordship's continued support and guidance are source of inspiration for all of us to organize program like this. Thank you, my Lord. I also extend thanks to judicial officers, registrars of High Court of Karnataka, legal research assistants, High Court technical staff, trainee judicial officers, law interns. Your dedication to excellence continues to make events like this memorable. Thank you very much. Last but not the least, my heartfelt thanks to our staff here in Judicial Academy for striving hard to organize this program. Let us carry forward the knowledge and information gained here today. Thank you all once again. Thank you so much. One more announcement from here. The high tea is arranged in first floor. We have arranged high tea, and I request all the participants to have snacks and tea. Thank you so much.